Good morning, everyone. It is my pleasure to welcome everyone here as we convene the 20th meeting of the Joint Select Committee on Human Rights, Equality and Diversity. This public hearing is being broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I would like to welcome the members of the Immigration Division, officials from the Immigration Division, and from the Ministry of National Security who are here with us this morning. My name is Nian Gatsby-Dolly, and I'm the chairman of the Joint Select Committee on Human Rights, Equality and Diversity. And at this point, I would like to invite members of the committee to introduce themselves, starting with on my left.
Good morning to all, the national public, and to the members of the Immigration Department. Esmond Ford, member of the committee.
Good morning, Dineshwar Mahabir, member, Independent Senator.
Good morning, Kazim Hussain, member.
Dennis Moses, member. Good morning, Saddam Hussein, member.
A pleasant good morning to all of you. Vidya Gaidin Gopi Singh, member.
Thank you so much. And at this time, could we have the officials who are here with us introduce themselves, starting with the Permanent Secretary acting in the Ministry of National Security.
Good morning, Madam Chair and members of the committee. My name is Vashti Srikrishnan Singh. I'm the acting Permanent Secretary in the Ministry of National Security. I will ask my team to introduce themselves, starting on my left.
Good morning to the members of the committee. I'm Shamin Gandhi Andrews, the acting Chief Immigration Officer.
Good morning all. Joanne Nelson Joel, Assistant Chief Immigration Officer acting.
Good morning. My name is Dennis Neely. I'm acting Immigration Officer 4 and Administrator of the Immigration Detention Centre.
Good morning. Curtis Belford, Deputy Director in the Office of Law Enforcement Policy, Ministry of National Security.
Good morning to the members of the committee. My name is Lassie Barrett, Administrative Officer 2 of the Immigration Division.
Good morning all. My name is Kent Downer. I'm the Senior Emergency Medical Technician at the Immigration Detention Centre.
Thank you so much for being here with us this morning. The Immigration Detention Centre was envisaged as functioning in accordance with international human rights instruments and treaties, with universal respect for human dignity and fundamental rights and freedoms. The Centre was created pursuant to the state's human rights obligation as a member of the international community, committed to the observance of the fundamental human rights of individuals of every creed, race, religion, cultural belief, or nationality. The U.S. Country Reports for Trinidad and Tobago 2012 to 2016 on human rights, in reference to the Immigration Detention Centre, states, the average length of detention was 1 week to 2 months, depending on the speed with which the government secured deportation. In some cases, detention lasted more than 4 years. The men's section was overcrowded. Prisoner abuse and medical neglect were problems. In 2013, at the Immigration Detention Centre, a Guyanese national committed suicide. And in 2017, various media reports emerged where unsavory conditions at the Immigration Detention Centre were highlighted. One quote stated, "Prolonged indefinite detention represents the most fundamental violation of the human rights of detainees at the Immigration Detention Centre. Indefinite detention is contrary to many human rights conventions and is widely recognized as a form of torture," end quote. In light of these national concerns, the committee's objectives this morning are as follows: to determine the treatment of detainees at the Immigration Detention Centre in Aripo. We had Santa Rosa, but we have learned that that has now been closed off. And to examine the physical conditions at the Immigration Detention Centre in Aripo. We were happy to receive written submissions, 4 written submissions, from the Ministry of National Security, Immigration Division, the Office of the Ombudsman of Trinidad and Tobago, the Living Water Community, and the Emancipation Support Committee. During the hearing, viewers and listeners can send the committee questions related to today's topic via email at parl101@ttparliament.org, that is parl101@ttparliament.org, on Facebook at TT Parliament, and on Twitter at TT Parliament. I'd now like to invite brief opening comments from Mrs. Singh, the Permanent Secretary Acting of the Ministry of National Security.
Good morning, Madam Chairman and members of the committee. The Ministry of National Security appreciates the opportunity to contribute to the Joint Select Committee on Human Rights, Equality and Diversity on the inquiry into the treatment of detainees at the Immigration Detention Center in Aripo. The Ministry of National Security is the arm of government that has the primary responsibility for ensuring and maintaining the security of our twin island state. The ministry's three-pronged operational mandate includes maintenance of law and order, public safety and defense against aggression, management of disaster preparedness and relief, and monitoring and controlling flow of persons into and out of the country. Given its mandate to secure the nation, the Ministry of National Security is focused on developing solutions to the multi-dimensional security challenges that afflict our society. And the ministry is cognizant of the need to ensure that all persons are treated humanly and fairly, and that due process is followed. The detention center was created in 2009 in response to the country's human rights obligations as a member of the international community committed to the observance of the fundamental human rights of every individual. At that time, it was agreed that the facility would be established at the Aripo Remand House to accommodate foreign nationals found in breach of our immigration laws. The configuration is in keeping with international best practices as required by the United Nations International Convention on Civil and Political Rights, the International Convention on Economic, Social, and Cultural Rights, and the Universal Declaration of Human Rights. The Ministry of National Security continues to strive to ensure that the processes and procedures for detention and repatriation stand up to legal scrutiny and are in keeping with current best practices. As such, given the focus as well as the objectives of the inquiry, we are pleased to be here and to clarify any matters you may have in this public forum. Thank you.
Thank you so much. At this time, we would like to start the questioning, reminding both committee members and officials that any questions you may have can be directed through the chair. And of course, our viewers and listeners have been apprised of how they can send their questions or comments to the committee for elucidation. I would like to start the questioning by drawing to the attention of the immigration officials the variance between the reports that concern the conditions at the detention center coming from the immigration as well as those coming from the other submissions we would have received. So we have received reports from the Living Water Community as well as the Emancipation Support Committee. And I want to just put on the record some of the concerns that they would have raised that are at variance with what would have been submitted by the Immigration Department, and then ask a question based on that. So some of the concerns that were raised, the main concerns were the 15-day to 2-year stay at the center, which has no definite end, the detainees not being apprised of their right to legal representation being denied when requested, persons being denied access to NGOs, which may afford them assistance. The NGOs themselves, when approaching the IDC, being denied access to the detainees. Detainees not being advised of their right to seek asylum. No process in place for complaints by detainees. No system to deal with language barriers. Lack of medical care and treatment for detainees. Asylum seekers being discouraged from seeking support. Physical, verbal, and psychological abuse being the norm. Valuables of detainees confiscated. Bullying by officers. Sharing of bed space. Detainees having to sleep on the floor without mattresses. Leaks within the dormitories. Insect infestation within the dormitories. Non-violent detainees being housed with those who are charged with violent offenses such as rape and murder. So these are some of the complaints that have come forward from the submissions we have received. And this is in direct variation with what was received from the Immigration Detention Center based on the Immigration Division's submission. One of the recommendations that came forward as well would have been an independent person or body being able to visit and to assess the truth of the matter with respect to what the conditions are at the center. So what I want to ask is, have there been any independent visits or assessments done on the Immigration Detention Center have there ever been any independent assessments, for example, by a human rights body or some civil organization that would be able to verify the truth of the matter between these two very different reports coming out of what happens at the Immigration Detention Center?
Good morning again, Chair. As far as we are aware, there have not been any independent assessments done. While there have been visits by the Emancipation Support Committee, the Living Waters community, we are not aware that those visits led to any independent assessments. Those visits would have been made to see specific detainees, and I'm aware personally that the Emancipation Support Committee and the Living Waters community would normally request visits through the Ministry of National Security, and those visits would be accommodated outside of the normal visiting hours. Once the request is made, they are facilitated. As to whether they would have visit the housing units, this may have occurred on one or more occasions, but normally they would conduct the visit in the visit area or in an office in the detention center.
Is it best practice in detention centers such as this one, because we've certainly seen it with respect to the holding cells and so on, that there is an international inspection of these areas on a regular basis so as to ensure that they comply with the human rights treaties that we are signed on to?
Okay. The Immigration Detention Center does not have cells. It has housing units, like a dormitory-style setup. Yes, it would be best practice. The issue here would be determining what is considered regular visits for an external independent agency. The other issue concerns security. Most independent agencies and/or individuals would be unwilling to go into the housing units, and that's the other issue. In terms of taking persons there, special arrangements would have to be made to perhaps remove the detainees put them in an outdoor recreation area to get civilians to go into the housing units.
Certainly, though, if this is the best practice, and this has been operating since 2009, this is 9 years later, and there have been no visits by any independent body, which is something that is being acknowledged as a best practice. So why has there not been any visits? Because certainly that can be arranged. It happens in other jurisdictions as regularly as once per year, where human rights associations are allowed to come in and to make those determinations and to actually see what's happening. Why has that not been arranged for the International Immigration Detention Center in Trinidad and Tobago?
Well, as I noted previously, Madam Chair, there have been visits based on requests made by the Living Water community and the Emancipation Support Committee.
Not to interject, but I'm sorry, but what I'm speaking about is the Immigration Detention Center itself, allowing itself to be visited in this way so as to determine whether or not, and for the public to understand that they are being compliant with the international standards, because this is where we are having a complete dissonance with respect to what is being said by the Immigration Division as well as what's being said by civil organizations. There must be an independent assessment that the Immigration Detention Center itself seeks to be able to put these fears to rest, and that is the best practice, but that has not been happening. So is there an intention for that to be put into the program at the Immigration Detention Center?
Yes, Madam Chair, you're quite correct. Again, the Immigration Division, the Ministry of National Security, has not initiated any visits by such entities. The visits are facilitated based on requests, but based again on international best practices and what you just said. Certainly the time is ripe for us now to initiate such visits in going forward, rather than waiting on a request from the particular entity.
Okay, thank you. Senator Mabir.
Madam Chair, it's a follow-up to a question that you posed, and that is, given that there were reports of bullying of detainees by the supervising officers, I just need to ask whether the Ministry of National Security has a special training program so that the officers who are supervising the detainees are specially trained to deal with this particular peculiar category of inmate. Thank you.
Okay, the officers who are supervising the detainees are all members of the Special Reserve Police engaged on contract. They are Special Reserve Police officers because, according to the Immigration Act, Section 15, only immigration officers or police officers have the legal responsibility to arrest and detain prohibited immigrants for inquiry or deportation. As part of their 12-week, 424-hour contact training program, they are exposed to training in ethics and integrity, the use of force, and a number of behavioral sciences, including emotional intelligence, psychology, sociology, communication skills, and so on. Specifically, as regards the use of force, they are trained to adopt the use of force on the basis of minimization, use the minimum amount of force necessary to get the desired effect, equivalence, force must equate force, the amount of force used must be similar to the amount of force encountered, as well as reasonableness. The force should be reasonable, being that any normal person placed in a similar situation would have done the same thing. In addition to that, the use of force is in keeping with the police service use of force guidelines, which is based on a use of force continuum, meaning that they could start from their mere presence, move on to verbalization, soft impact weapons like a baton, deadly force, and so on, but it's on a continuum, it could go around. In addition to that, if a detainee has a complaint, it is the responsibility of the detention manager, who is an assistant superintendent of police, to conduct an investigation based on the claim.
Clarification, so therefore, the officers are police officers, by and large, and not prison officers?
No.
Thank you very much. Since Madam Chair has indulged me, I would like to ask a second question. And the second question is in relation to a submission that we received with respect to the suicide of one of the detainee, a female detainee. And I would like to ask anyone, I see a medical technician officer here, whether the detainees are afforded mental evaluations when they are admitted to the center, and whether someone trained in psychology or someone trained in that field, similar cognate field, is required to evaluate the detainee with respect to estimating the risks of this individual inflicting harm on himself, or simply to ensure that there is some separation between the detainee who is experiencing a bona fide mental health issue and to ensure that other detainees do not develop these mental health problems within the detention center?
Thank you, sir. The infirmary is staffed by 4 trained EMTs. On arrival of a detainee at the institution, all detainees are screened by the EMT that is on duty.
EMT, I don't understand.
Emergency technician on duty. If any tendency of mental illness is identified, that detainee is referred to be seen by a medical doctor who visits the institution once weekly. When that detainee is brought before the medical doctor, the doctor would, if he determines that the detainee requires assistance with respect to a psychological or mental issue, that detainee would be referred to the hospital to see a psychiatrist, and an appointment would be made by myself for that detainee. And at some time subsequently, the detainee will be escorted to the institution to receive that mental assistance and guidance.
Give us an estimate, or give me an estimate of how many detainees were granted such a privilege of being mentally evaluated over the last 10 years or so?
It has been not many detainees. It may have been approximately maybe 3 or 4, if so many, over the last 4 or 5 years, 6 years. What has happened, detainees, when they are seen by the doctor and referred to a psychiatric clinic, they would be seen by the psychiatrist at the institution. Firstly, they would go to the institution that is closest to the detention center, which is the Rima Health Facility, and would be seen by at the psychiatric unit by the psychiatrist. If there's need for further evaluation and treatment, a recommendation could be made, and the detainee may be referred to the sentence institution.
Follow up, Madam Chair. Do you think, given that only about 4 or 5 persons were evaluated as referred by the medical doctor, there was one suicide? You see, this is of concern to me. I imagine in a regular prison environment, I will not be surprised to see a suicide there. It might be shocking, but I won't be surprised. But in a detention center for someone who has violated the immigration laws of Trinidad and Tobago, for us to have a suicide signals to me that maybe there may be a lot of individuals who are experiencing depression, anxiety, the various conditions which require mental evaluation. Do you think, as a medical technician that it may be a good idea if a trained psychiatrist or psychologist were to evaluate all of your detainees to determine which one of them may be at risk and which ones may not be at risk. It may be that only 4 were caught given the system and the procedure you have, and that perhaps there are many more in there suffering this kind of ailment. But do you think it would be a good idea for everyone to be evaluated?
Probably, but that decision is usually made by I am not an expert in the field. I am a professional as an EMT. The doctor, who is the expert, he is the one that would likely could make a decision like that.
Just a very quick question to follow up on your point. If the EMT, right, that's the emergency medical technician,
yes,
and that's the one that evaluates all detainees when they come in.
Yes, ma'am.
And if that person detects that there may be something wrong, then it is referred for the medical doctor's visit.
Yes.
In the period of that time between the detection of something that may be wrong and the visit, is that detainee kept with everyone else? Is there a separation of them at all?
Yes.
And in some occasions, if the detainee shows signs of being violent or not taking instructions, he could be separated in a separate unit until he is seen by the doctor, who visits on a weekly basis, sometimes twice weekly. So it wouldn't be very long.
So once something is picked up, there's mental instability, and there's a suspicion that person is kept separate if they seem to be violent.
Yes, ma'am. And in some cases, the doctor may be contacted because the doctor is on call. He may be contacted at that point in time, and he may recommend some type of medication or treatment. Even he may recommend hospitalization.
So are there detainees at the IDC that have been charged with criminal offenses?
I cannot say, ma'am. I am not given that type of information.
It may be a question for someone else to answer.
Yes, Madam Chair. There are some who would have served their time at the nation's prisons, and they come to the Immigration Division for deportation. And those persons are kept for the shortest possible time prior to deportation. So there are some, as it is currently, there are probably 9 of them currently at the detention center who would have been charged for possession of narcotics.
Madam Chair, if I may.
Let me just clarify there. Sure. But they come after they've served their sentence. So they're not criminals at that point.
Well, no, they might be considered criminals having a criminal record.
But they're not criminals
but they would have
point.
served their time or paid their fine prior to coming to the detention center for deportation.
And are they kept in circulation with everyone else, or are they kept separately?
They are kept in circulation with everyone else because, as Mr. Belford would have noted, it's a housing unit. There's not separate cells. Within the facility, there are 5 in the male area. There are 5 separate housing units. And on the female side, there are 2 housing units on the female side.
So if someone is to be kept separately, as would have been discussed before, how are they separated?
Right. So, Madam Chair, there is an administrative segregation unit in the male housing unit where we have 7 independent cells. That's where those persons are kept. It is not generally used to house detainees. It is used for administrative segregation purposes. If somebody develops some illness that we are unaware of, say scabies, chickenpox, if somebody may have homosexual tendencies and they are being attacked by other members of other detainees, if somebody has breached some disciplinary guideline, and as the EMT said, if somebody displays signs of mental illness. I should note as well that we have had one case where a detainee feigned mental illness by claiming that he wanted to commit suicide and so on. The doctor was contacted, and that detainee was taken to the St. Anne's Psychiatric Hospital and escaped the said day from the St. Anne's Psychiatric Hospital. Okay. So we also have cases where detainees may feign mental illness to get out of the facility.
Are there, if a detainee is in there for, who has been released from prison for a violent crime, are they kept in normal circulation as well?
Yes, they are. As we noted earlier, we do have housing units. It's a dormitory style with double deckers. We do not now have the facility to classify, to effectively classify detainees based on why they are there and separate them accordingly.
Do you think that this is the best practice?
No, it's not. And certainly that is something that we are looking at, but based on what we have now, we are unable to do that.
But this is a refurbished Immigration Detention Center.
Yes, it's the same facility that has been refurbished.
Were there cells before?
Housing units.
They were always housing units, dormitory-style housing units.
Yes, yes.
So in the refurbishment, it wasn't taken into consideration at this point that that kind of separation would be the best.
Yes, detainee classification was taken into consideration. And there is the housing unit E. Yeah. Right. There is a housing unit E that could house 12 detainees. That is still being refurbished. And once that is done, that is where we intend to put persons like that who are released from prison pending deportation. Okay. But that refurbishment is still taking place.
So therefore, the assertion that people who have been charged and released from prison for violent crimes are in normal and circulation and rotation with people who are just there for transgressing immigration rules.
That happened in the past. We are working assiduously to streamline and adopt our detainee classification policy.
Okay. Okay. So on this particular issue, okay, so we have Ms. Dean Gopi Singh, and then we'll have Senator Hussain.
Yeah. Just for a little clarification, I recall 2 Estonians had some problems. One matter was being tried before, I believe, the first instance court, and the other one was detained. The judge was very annoyed about one being detained so long. So can you clarify what really went wrong with that particular Estonian?
Okay. As far as our records show, we had one Estonian national who was convicted for drug offenses. And we attempted repatriation a couple of times for that particular individual, which failed because of the routes that we were trying to take the person through. And that is one of the major challenges for the Immigration Division in repatriating any person. There were 2 Bulgarian nationals. Bulgarian? Yes, there were 2 Bulgarian nationals who were before the courts for various offenses. And for, yes, they were there for skimming and other such offenses. And they were repatriated as soon as we could make arrangements for them to be repatriated, verify their documents, and get tickets for them to leave. Part of the challenge with the Bulgarians, of course, was the language barrier. And the only person who spoke that language had to come from St. Lucia. Outside of that one, there was a Latvian national who was also convicted for narcotics, and that person was repatriated. There's one to be repatriated now?
We have Estonian.
Okay. So there are a number of challenges to repatriation with the individuals, and it stems from either not having travel documents, what route we could take them through, because some countries do not want us to pass them through a particular country. And for criminal offenses, we must escort them, and there must be 3 escorts. For one person.
Okay. To get the interpreter from St. Lucia is really a stone's throw away. So how long does it take to get that person from St. Lucia to do the interpretation for the Bulgarian? And how long those persons remain at the detention center?
The interpreter of course, we depend on their schedule. So it is whenever they can fly into the country and when we can have the funds available to pay for them to come to Trinidad and Tobago. In the case of the Bulgarians, they simply wanted to go home at the end of the day, and they did not appeal any deportation orders, and they indicated that they simply wanted to go home, and arrangements were made for them to go home. The interpreter at the time, which was, I don't remember the person's name because it was the same interpreter that the court had used, would not have been available for at least 2 months. So we are dependent on the schedule of interpreters. Like I said, when there are very few interpreters for a particular language, then, of course, we have to wait until whenever they're available before we can proceed with anything.
The estimated time they remained detained, how long?
I'm told they stayed at the detention center for 3 weeks.
Thank you very much, Madam Chairman. All detainees admitted to the Immigration Detention Center have fundamental rights to humane treatment. According to a chart I saw here, 537 persons were trained. Can you advise whether staff at the Immigration Division undergoes any such training in humane treatment? And if so, are there any active training plan to ensure that all persons are adequately trained and given refresher courses to offer best quality practice?
The answer to that would be yes. In terms of the management of the detention center, there are two things. There are the detention officers who are there to detain or to guard and manage the detainees. The immigration officers are there to ensure that they are informed about the status of their case, when they would be repatriated, and to have that type of liaison. During the training for all officers, they are trained in different facets of the law, international best practices. The enforcement unit was also trained. The enforcement unit and the officers who are assigned to the detention center were trained in the defense and defensive tactics and how they should treat with detainees.
Okay. I should add, Minister, that in terms of the detention officers who are Special Reserve Police officers, we have also introduced in the curriculum cultural sensitivity and conversational Spanish for public safety officers. So that now forms part of their 424-hour induction training program.
So just before you follow up, so you're saying that the police officers who are assigned to the IDC have special training?
Yes, ma'am.
Okay.
Follow up to Senator Kazim Hussein's question, and that is, they are trained, but my question is where? Are they trained at the police academy? Can I see a copy of the curriculum, the courses, the content, and so on? And I'm just curious as to the Special Reserve officers. Do they undergo a screening process to ensure that they are amenable to treating with this type of detainee as opposed to, say, someone in a prison? It's a little bit vague to me, and I'd like to know about the quality of the training that they receive.
Okay. So in terms of the screening process, from the application process, they do an entrance examination. Following the entrance examination, they are subjected to interviews. Following the interviews, we move to the background or character investigation. Following that, and based on success, they move to the medical evaluation. From the medical, they have a psychological evaluation. And from the psychological evaluation, they move to the induction training program, the 12-week induction training program. And again, they are required to complete the same program that Special Reserve Police officers in the police service complete. But because they are then assigned to the Immigration Detention Center, That's where we're moving now into cultural sensitivity, conversational Spanish, defensive tactics, and these are the issues that are specific to the job that they are being engaged to perform.
Are they on contract or are they full-time employees?
They are on contract.
What's the length of the contract?
3 years.
Oh, they're on 3 years.
Yes.
Just to clarify, 12 weeks, how many hours is the training?
424 contact hours. That's the induction part, Ma'am? Madam Chair?
Yes.
The 424 contact hours is the induction training.
Yes.
From that, they move on to developmental training.
Okay.
The 424 contact hours is a requirement to be a special reserve police constable. But as I said, because they move on now to the Immigration Detention Center, they complete further training for that specific function. That would be 24 contact hours to start. But then developmental training is something that is ongoing. And
so
of course,
throughout their 3-year contract.
Exactly. But we can't take everybody at the same time, so we do it in stages. Because their services are required, of course.
Okay.
Yes.
Thanks, Madam Chair. To the Chief Immigration Officer acting, I would like to know clearly, how does one become a detainee in Trinidad and Tobago?
Persons who are found to be in breach of the Immigration Act, either they have entered illegally, they have overstayed their time, they might have committed criminal offenses which have placed them within the prohibited classes. Once they come to the attention of the Immigration Division, they are interviewed. The officers at the enforcement unit would do an assessment of them to see whether or not we can either release them on what is called an order of supervision. They would look at where they're living, who they might be staying with, whether they have any family members or any friends who are willing to support them. Detaining anybody is as a last resort at the detention center, because the center could only hold so many people. So that once they are found to have breached the Immigration Act, anybody could be detained. Putting them at the detention center, like I said, is a last resort depending on the circumstances. Clearly, if they have committed some criminal offense, then they will be detained pending repatriation. If they may have entered the country illegally and they have been prosecuted, they will end up at the detention center pending their repatriation. And once they can be identified, because a lot of the persons who come to us have no identity documents, so that we have to verify nationality, we have to verify their identity before we can even move forward with some of our processes. We have a process, like I mentioned, an order of supervision, which is akin to bail, that the Chief Immigration Officer can release anyone on an order of supervision with certain conditions. And currently, we have 455 persons on orders of supervision who are all in breach of the Immigration Act. And we have, at this point in time, we only have, 85 males and 35 females at the detention center as at this morning. So that's pretty much how they may become a detainee. The fact is they're in breach of the Immigration Act. And we will do our assessment depending on what it is. Some of them might have overstayed, have been found working without a work permit. If they can be identified, and if there's somebody willing to support them, house them, because the conditions for release would be that they have some place of abode, somebody that we can contact, somebody who is willing to put up what is called a security bond, which would assist in any repatriation. And those persons would be released. So at any given time, there are actually more persons out on an order of supervision than at the detention center.
Would it be wrong of me to suggest that if our immigration department are creating detainees?
When you say are creating detainees, right. I'm not sure, because the law empowers us to arrest and detain pending an inquiry. And therefore, depending on the circumstance, and more often than not, the persons who we have at the detention center, either, like I said, fall squarely in the prohibited class, or we are unable to identify the individual. If we are able to identify the individual and depending on the other circumstances, they will be released.
Right. In terms of, quote unquote, the red tape, the bureaucracy that sometimes may take place, and if I may probably want to say that having 1 or 2 instances of individuals coming to my Member of Parliament office with regards to saying that they have submitted all the necessary documentations, there's a delay, they go to Richmond Street, they go to Frederick Street, they go here, they go there, and there's some sort of delay. File cannot be found, it's at this department, they cannot go to this particular department. In terms of the bureaucracy that may entail, how, as the immigration officer, again, would it be wrong of me to suggest that there is something that's not adding up in some instances?
I think, through you, Chair, I believe that we are mixing a lot of things here. And from what you're referring to and the correspondence that I would have seen from you, relate to those persons who may have applied for permanent residence. Mm-hmm. And that is something completely separate. Okay. And apart. And there's a process to deal with someone who has applied for permanent residence. And the role of the Immigration Division in that respect is to interview and submit a report to the Permanent Secretary. More often than not, persons who have applied for permanent residence simply need to go to the Immigration Division to ensure that their landing status is kept current, in that they must go and seek an extension of stay. So persons who do not go and seek an extension of stay can end up, of course, in breach. They are now illegally in the country because they have no permission to stay. And those persons are the ones who invariably end up on an order of supervision.
No, but then the timeline, Madam Immigration Officer, between the person getting that document, there is a presumed runaround that takes place. And, you know, whether it is that the delay is happening in order to make a certain result. You know, somehow or the other, there's a disparity between, you know, the communication that comes out of the Immigration Department. And I think I'm trying to see if I can get some clarity, you know, with regards to it.
If I may assist, I remember is asking, does the delay in processing the extension of stay result in many people being now illegally in the country and now having been at the risk of being detained if they don't have this extension? Are the processes working well enough that we can be confident that people who are applying for extensions of stay are getting them regularly enough so that they don't end up as detainees?
Persons are obligated to go to the Immigration Division before the expiration of their landing certificate to apply for an extension of stay. They cannot come months after their landing certificate has expired to get an extension of a landing certificate that has expired.
And is that a general circumstance?
It is a general circumstance. Since we moved into the new building, because there were challenges between 2014 and 2016 when we had a challenge with one of the buildings that was closed. Since we moved into the new facility at Richmond Street in October of 2016, all of our services have resumed fully for extensions of stay and for persons who have applied for permanent residence to be interviewed. And we have also assigned more officers to those two sections to deal with persons. So right now, we are actually seeing persons who are walking in to get an extension. Like I said, if it is their landing certificate that was given to them has already expired, then they fall into a particular class and they are referred to the enforcement unit. And when they are referred to the enforcement unit would more often than not put them on an order of supervision. Depending on the circumstance at that point in time of the particular individual, they may be detained at the detention center. if there's no support, depending on their unique circumstances, they may be detained and put before a special inquiry officer for that special inquiry officer to determine whether or not they should be deported or whether they should just be given voluntary departure and allowed to leave.
Senator S. Hussain.
Thank you very much, Chair. Chair, I just have a follow-up question to Member Ford and then my substantive question. With regards to the amount of detainees that are currently in the center, or from your experience in the past, what is the most common breach of the Immigration Act that has so many detainees in the country? And of the amount of detainees, what percentage would be those that commit criminal offenses?
It's almost half and half between those who have overstayed their time and found working illegally and those who have entered the country illegally. And I can give you an example. Of the 85 persons who we have, 85 males and 35 females who we have presently, 52 of them are at the detention center for illegal entry. 40 of those persons were found to have overstayed their time and would have been working illegally. And in addition to that, they may have expired travel documents and whatnot. And 12 of those individuals are there for possession of drugs. The others who are there for, there's one who's there for importing counterfeit currency. One who was there, a few of them who are there for tendering fraudulent documents and would have been prosecuted before the courts. And typically that's what we see. Half and half with overstaying and in breach of the Immigration Act, and those who would have entered the country illegally. And maybe it varies from time to time, maybe about 5 to 10% who would have committed criminal offenses.
Thank you. I just want to carry the conversation back to the structural issues that we were addressing previously with regards to the IDC, the Immigration Detention Center, and the rehabilitation works that have been undergone recently. Now, I noted in the submission of the ministry that there was an upgrade to the entire facility in terms of the air conditioning unit. Also, I would have seen that there's no provision for potable water or cool, wholesome drinking water supply. And also, I saw that there's a repair to a perimeter fence, but this project is deferred to 2019. Now, my first question is, was it taken into consideration to have potable water available to the detainees at the center? Because there have been issues raised from the Living Waters community where a person is only provided 300 mLs of water per day. That's almost the size of a chubby bottle. From the refurbishment, why wasn't this taken into consideration? That's my first question. So I'll allow you to answer that, and then I will pose my second question.
We provide bottled water to the detainees, and they are provided with the bottled water as and when they need it. So that, yes, I agree that perhaps we should have some kind of system, some kind of cooler, some water dispenser at the facility. But more often than not, when we put a water dispenser at the facility, and there was one before, it was destroyed by the detainees themselves, which is why we resorted to the bottled water.
We also provide hot water for the detainees at mornings. Sometimes they require hot water, but we have had to restrict that use since detainees threw hot water on 2 detention officers who were hospitalized and have since resumed duty after one of them suffered second-degree burns about the body. So those are some of the challenges that we face with the detainees. So we have had to restrict the use of the hot water as well, closely supervised.
No, I'm very surprised that the water dispenser was destroyed. And these detainees supervised on a 24-hour basis to ensure that there's no defacing of the state's property?
Yes, they are. Yes, they are supervised on a 24-hour basis, but we don't have the ratio of supervision is 1:8 based on international best practices, meaning 1 detention officer to 8 detainees. It is impossible at times for 1 officer to be around all these detainees at the same time. So things do happen. It is, of course, contained immediately. All right, like the incident with the hot water, for example. So we provide a percolator for the detainees during the morning breakfast. That percolator was made available to them in the indoor recreation area. And of course, the detainees and them felt that they were not getting enough. There was an issue with breakfast, and there was a struggle between 2 detainees of 2 different nationalities. The detention officer tried to contain that struggle, and in that process, they threw the hot water on 2 detention officers, and that's what happened to them. So it is impossible at times when you have 85 persons. Remember, we're looking at a ratio of 1:8 based on international best practices. But when something does happen, it is contained speedily.
Okay. The second question is with regard to the perimeter fence. Is there an issue with the fence? That is why it was listed as part of the repair works?
The fence that we have is a chain link fence. We're trying to get wire walls in keeping with international best practices.
They said repair to the fence. Is there an issue with the fence? That's under the rubric that we got, repair to perimeter.
Well, I think it's basically to enhance its structural integrity that exists now. Yeah.
If I may, a question now dealing with the staffing at the center. Based on the submission, I am counting between detention officers 1 and 2, 83 officers.
Oh,
based on your submission now. You've indicated that what your preferred or what is best practice would be 101, about 150, about 170 detention officers, 1 and 2. So you have about 83 now. You've indicated that you need almost double that. Right? This is based on your submission, pages 12 and 13. And if I'm following that the detention center is designed for 158 detainees, and you have about 120 now, right? I find the ratio of, I'm counting those only as the ones who would be in direct contact with the detainees. So if we're looking at present, 120 detainees to 83 detention officers, 1 and 2, and you are indicating that you would want 170 or so in the center that's designed for, at maximum, 158 detainees. I find the ratio to be a bit high. You mentioned 1 officer to 8 detainees earlier. Can you give us some clarification about that? Because it seems to be off. You have 120 detainees now, 83 detention officers, 1 and 2. How is that?
Yes, Madam Chair, there is a definite error in the numbers, and we do apologize for that. But just to add some further clarity, in terms of the allocation and deployment of the detention officers, we have detention officers that work at the gate. We have detention officers that work on the perimeter. We have those that work in the housing units. And we have a special team called the Special Operations Team. They work outside of the detention center doing escorts to and from the airport, various ports, taking people to court and so on. So there is a definite error in terms of the numbers. I can't get the specifics now, but yes.
Is it an upward error or downward error?
An upward error, clearly. Yeah. Yeah.
Okay, so maybe
because based on the figures we have now, we actually should have 20 officers who are assigned to the Special Operations Team, and they work closely with the Immigration Enforcement Unit in terms of taking detainees to and from the facility for various reasons, as I noted. And the other officers are working at the detention center, either externally, perimeter and gate, or internally in terms of the housing units.
So you overquoted here?
Yes.
You overquoted what you have or what you want?
What we want. We would have overquoted.
So you actually have 83 officers? Detention officers 1 and 2?
No.
109 would be all the assistant detention manager, detention supervisor. I didn't count those because I'm assuming those are part of the administration.
Yeah.
So I'm referring only to the 1 and 2 who I think would be in direct contact.
Yes.
It should be approximately 83, give or take 1 or 2.
No. And 28. Yes, Madam Chair, it should be 66 and 28, 14.
So there's an error with what you have as well?
Yes, Madam Chair.
So you don't have 83?
No.
How many do you have?
Right.
Do you have it on hand?
No, Madam Chair.
Okay, so could we ask then
yes,
for you to submit revised figures for what you have? Because what you have in the submission doesn't gel with the 1:8 ratio.
Yes, Chairman, we will seek to get the specific figures on that for you.
Okay, so we will have that?
And submit in writing, yes.
Okay, appreciated.
Thank you, Chair. At page 22 of your submission, it is stated that the Immigration Detention Center is designed to accommodate 120 males and 38 females. So at any point in time, we may have, like, say, 158 persons, or if we round it off, we might have an estimate about 200 persons. Now you're saying you have 85 males, 35 females, so we have about 120. I have turned to Appendix 4, line 40, food at the institutions. And what I'm seeing here, there's a gradual increase in the allocation. And what really stood out is that 2015, $5.5 million was spent, $5.25 million in 2016, and when it was revised provision in 2016, we reached up to $6 million. So I need to have some clarification, and perhaps if you can justify the allocation of $6 million spent, that was spent for how many persons? Because we are seeing the maximum you could hold is perhaps 200 persons. So how we could justify $6 million spent on food at the institution?
Okay. It can hold that amount at any given point in time, but you have to remember that the numbers that pass through the detention center at any given time change. So while we may have 85 males today, by tonight we may have 100 because of the exercises that would have been conducted overnight in the last 2 days. So the numbers change. So what the total is you have to look at the numbers of persons who would have passed through the detention center over the year. And we would have sent the numbers of persons who would have, yeah. So, so it would be the numbers that would have passed through the detention center. In addition to that, the caterer would have increased the cost of the meals. Prior to, what day was it? 15? Right. It was $50 for 3 meals per day, per detainee. That was increased to $80 for 3 meals for each individual per day. And that would account for the increase in the amount of money that we would have spent in food for the detention center.
Is it then it may be more prudent that the processes in expediting these detainees, you have not these inordinate delays, so we can save some of this monies. And because I'm looking at also one of the submission, and one of your challenges experienced is that the unavailability of funds to purchase ticket for the repatriation. So perhaps if the processes are expedited, we can have some money allocated to purchase tickets for these detainees, and the process could be more fluid.
Agreed. Okay. However, as I mentioned earlier, the length of a stay at the detention center is dependent on a number of factors. One would be the identification of the individual, the acquisition of travel documents for the person, whether they require an escort to their home country. And that in itself presents, like I said, presents a challenge for us. We try as far as possible to repatriate individuals as quickly as possible. We have improved our processes in terms of from detention to going through the process of a special inquiry to ordering somebody deported or given voluntary departure. And at the end of that process is when we require an airline ticket for their repatriation. More often than not, persons provide their own tickets, or their family members would provide tickets for them to leave. If not, then the state is required to purchase a ticket. And that, of course, is a process where submission is made to the permanent secretary for funds to be made available for the purchase of a ticket. And if they are to be escorted, for funds for the tickets and whatnot for the escorts. So yes, but we have significantly improved our process in terms of from detain or arrest to order deported.
And if I may right there to interject, as
yes.
you're answering, what does that significant improvement represent in terms of time?
It represents adding more staff to deal with the persons in terms of writing their reports, doing the investigation, liaising with foreign missions to get identity documents for the individuals, liaising with Interpol to do traces on the individuals, and following through with Interpol on that.
So have you been able to measure the decrease in detention time, in average detention time for the detainees at the center?
Yes, because at least 2 years ago, more often than not, persons would have remained at least maybe 6 months to a year before we could have done anything with the individual in terms of being able to identify them and acquire travel documents, etc., and repatriate. The persons who are there for longer than that, we have more challenges in terms of identifying them. But that has been reduced to at least 2 weeks to 4 weeks from 6 months in terms of keeping time. Yeah.
You can say average detention time has decreased from about 6 months to 2 weeks.
Yes. 2 weeks to 4 weeks, depending on the circumstances and where the person would have to travel and how quickly we can acquire documents for their repatriation. But like I said, we have increased resources to deal specifically with the detainees.
And that brings me to the point, increase in resources. Is it then that this contract employment at line 16, in 2013, $0 allocated, 14, and then we have reached $8 million allocated. How many persons I don't know if you have the figures or the numbers, but from 0 to 8 million. So how do you account for $8 million being allocated for contract employment? And how many persons? How many persons?
Prior to 2015, they were on 3-month contracts. They were on short service contracts. And then we got approval for them to go on 3-year contracts from the CPO with the relevant salaries and whatever allowances they would need to have. And there was also an approval to increase the number of detention officers. When we created the SOT. All right, when we created the SOT. So we increased it by at least 22 officers.
Mr. Ford.
Chief Immigration Officer, in terms of the dollars we are now hearing, wanting to increase these detention officers, the repatriation, if we expedite that aspect, we would not have the need for all that financing that my colleague, 2 colleagues have been mentioning, food and all those different things, and we could then relocate these different detention officers to different positions in the Immigration Department. Have you all done a survey, looked at the statistics in order to weigh the pros and the cons and the cost benefits with regards to what you're now explaining?
Like I said earlier, it's a fluid system at the detention center because at any given time we may have no detainees or we may have close to 200 detainees. All I need to do is to send my officers in 2 areas in Port of Spain and in South, and I could end up with at least 400 people who are illegally in the country.
And again,
and I have
it comes back
no
to the
place
question,
to put them.
And it comes back to the question, Madam, with regards to your division in the red tape and the bureaucracy in creating detainees. Because you're saying you know where you can go and collect them.
No, I would disagree
with
that.
Why are we not dealing with them before the scenario where you have to go to pick them up?
At the end of the day, when someone enters the country legally and they are granted permission by an immigration officer to stay for a particular period of time, anybody who wants to stay longer than that, the obligation is on that individual to go to the immigration division to seek an extension of their stay. If they do not come to seek an extension of their stay and their landing certificate has since expired, they have now ceased to be a permitted entrant into Trinidad and Tobago, and they are subject to deportation. Detention, arrest, detention, deportation. When we go out on an exercise and we detain anybody, and we would go through our process, we would check our records to see if the person is legally in the country, if they came through a legal port of entry, and we would do an interview with that individual to find out what their circumstances are. And then we would make a determination as to whether they should be detained or whether they should be put on an order of supervision. I quoted 455 persons on orders of supervision. So I disagree that we are creating a situation. The onus is on every person to report to the Immigration Division for a service.
Is there a fear of these persons coming to your division?
There cannot be a fear, because if they are to remain in any country legally, they are the ones to approach the authorities. So that the onus is on that individual to come to immigration and not find themselves in an irregular situation, which would then and can lead to detention and deportation.
Okay. Madam Chair, I think, again, in the initial response, in terms of the financial aspect that my 2 colleagues, right, Senator Hossain and Mrs. Gayadeen Gopi Singh, with regards to the financial costing of the division versus the repatriation, when we look at those statistics, I think it may cost the taxpayers less in order to ensure that we get these people out of the country.
If I followed closely, the average detention time of 6 months has been reduced to, on average, 4 weeks. That is in a response to trying to get the detainees out faster. The question that's being raised, and I'm not sure if it's been fully answered yet, is the increase in contract employment. That came about, if you can just guide us through it again, how did that come about to increase so sharply?
Madam Chair, when the Immigration Detention Center was established in November 2009, the detention officers were then engaged on what is termed a short service contract. I think it's
Would
only...
that have been picked up in a different line item?
Yes, it would. Yes. So it's only in 2014 that
would have been other contracted services?
Yes.
So the decrease in other, line item 28, other contracted services would have been mirrored by an increase in the line item 16, which would be contract employment?
Correct. Yes.
And that would have reflected the change from short-term employment to contract employment. Okay.
Thank you very much, Madam Chair. I want to shift a little bit away to a human rights issue. And that is, we are speaking about detention. Detention represents the loss of much of someone's rights. He has some rights in the center, but his freedom of mobility, freedom of movement, and so on have been taken away. Yet in one of the submissions that we received, it was stated that there were detainees who were not informed of their right to legal representation at the detention center. And I would like to know two things. One, what is the process that is available for a detainee so that the moment he has been admitted to the center, he can obtain legal representation, say from legal aid or some other arm of the state? And second, what is the role of the embassy in all of this? We do have embassies here. Oh, I've heard the problem with the Bulgarian. I don't know if we have that type of embassy here, but certainly there must be a role for the legal arm of the state to provide representation, even though they are not our citizens, they are on our soil, and they must have, their rights must be protected as well. And second, their embassies must be involved in some way, and I am not sure how. Could you elucidate on both, please? Thank you.
Thank you, sir. We want to inform the committee that when a foreign national is detained, even before he gets to the Immigration Detention Center, he is advised of his right to have an attorney, to have a friend, to have a relative, anyone come to his aid. As well, through the Ministry of Foreign and CARICOM Affairs, all embassies are informed, all embassies and high commissions are informed if their nationals are detained and taken to the Immigration Detention Center.
Follow-up question. Were there any cases, or is there any case in which a detainee was denied legal representation? Is there any case, to your knowledge, where a detainee has complained that the process you outlined was not complied with?
To my knowledge, there have been no cases like that. The detainees are, the embassies and high commissions are free to go to their nationals, as well as attorneys are free to go to the detention center to speak with their clients.
And many of the detainees may, of course, not have much by way of finances. Is the legal aid department working closely with the detention center to afford these detainees whatever representation they may require or they may request?
As far as I understand, in prior times, the legal aid has not been involved, but now the legal aid is involved in representing people who require that assistance.
You can give the committee the assurance that every single detainee at the Immigration Detention Center can and will receive legal representation if a request is made in some form, at the last resort being legal aid.
Yes, for those who require it,
who request it.
Yes,
yes, thank you.
I just want to go back to the question that the answer that troubled me the most with respect to the meals. I was very surprised. Now, when Member Guiding Gopi Singh quoted the figure, this was the actual figure for food for 2016, which was $5.2 million. Now, when I look at the, sorry, right, and it does, we're 5.2 for 2016. Then, when I looked at the figures that were provided to us, there was about 1,146 persons at the detention center for that year. And we're saying that we're paying $5.2 million to feed 1,146 persons who are detained, and $80 per meal. And when I looked at the menu, we see that cheese spread, sandwiches in 4-inch buns, and a tea and a juice cost this nation $80.
It wasn't $80 per meal, sorry, just a correction. It was $80 for the day.
$80 per day for 3 meals.
What's the,
It's $80 per day for 3 meals. That was increased from $50 per day for 3 meals. We should note as well that the person who provides the meals is a school feeding program distributor.
Can we have the name of the contractor, please?
Sure. What's the name of the
JD Freitas. JD Freitas.
JD Freitas.
Company Limited?
Yeah.
Yes.
Thank you.
If I may ask now, there have been reports that there's not a system in place for complaints and investigations at the Immigration Detention Center. What is the system in place when a detainee needs to make a complaint against an officer or so at the center?
The system in place currently is that the detainee may speak to a detention supervisor or one of the immigration officers on duty and make such complaint. Once the detainee is willing to give us that complaint in writing, an investigation is launched by the detention manager, who is an assistant superintendent of police, and he may assign another detention supervisor to investigate such complaints. Normally, if it's a complaint made by one of the male detainees, the female detention supervisor may investigate, and if it's a complaint made by one of the female detainees, you have a male detention supervisor may investigate to create a level of transparency. And if a complaint is made against a particular detention officer, then that officer supervisor would investigate. So if it's made against a detention officer, one, for example, we would have a senior detention officer conducting the investigation.
Madam Chair, who concludes these investigations? What role does the Commissioner of Police have over these investigations?
Well, if it's a use of force complaint, the Assistant Superintendent does the initial investigation, and that would, of course, have to go to the Commissioner of Police via the Office of the SRP Adjutant. But we have only had one incident in terms of a use of force complaint thus far.
Who is the SRP Adjutant responsible for that, and what is his rank?
The SRP Adjutant is a Police Superintendent Jackson currently.
Are you certain that when a report reaches to Mr. Jackson, who is an assistant superintendent?
Superintendent.
Are you certain that that report meets with the eye of the Commissioner of Police?
No, I am not certain. I cannot say.
What is the process? Does it end with an assistant superintendent of police?
No, in terms of use of force complaints, it is according to the police service regulations. The initial investigation is conducted by a first division officer, who in this case is the assistant superintendent at the Immigration Detention Center. And the findings of that report, because again the assistant superintendent belongs to the Special Reserve Police, is forwarded to the Commissioner of Police via the SRP Adjutant. But
how many such cases of brutality reports you all have had which reached to the Commissioner of Police desk?
Thus far, we have had one report of abusive use of force. that was submitted by a Guyanese national after he was repatriated through the Ministry of Foreign and CARICOM Affairs. That matter was investigated by the detention manager, who interviewed several detainees. The matter was concluded as being unsubstantiated because there was no supporting information from the detainees.
I want to ask a question. For transparency purposes, because we have persons at the detention center who are supervised by the detention officer, who is also supervised by a manager, who is also part of that process. And when a report reaches to their attention, what authority does the Commissioner of Police have over that detention center in terms of having an external investigator involved in reports such as those?
Well, the Commissioner of Police shares hybrid responsibility for the Immigration Detention Center, in that that is the person who appoints the Special Reserve Police officers who are engaged on contract as detention officers. So again, hybrid in that they are employed by the Permanent Secretary, Ministry of National Security on contract, but they are also accountable to the Commissioner of Police who appoints them and gives them the legal powers to perform as police officers.
I want to submit, and I take the point of Mrs. Jennings-Smith, that I do not believe, I don't know if you believe that that complaints process is robust enough and independent enough for a detainee to feel comfortable reporting, because you're reporting within the same system, you're complaining to the same people who are supervising you. And of course, there would be the intimation of some type of bias, because all the officers and you're complaining on an officer. Do you think this is robust enough? And are there any plans to introduce some sort of independence into the complaints process?
Well, certainly the system is not robust enough. We have been looking at what applies in some developed societies, detention centers, where they have an external complaint mechanism. And that is something that we are still looking at to see how it could work in Trinidad and Tobago.
Mr. Ford?
There have been some reports where certain persons who have been at that detention center who came up with their passage money, or some family member or somebody came up with their passage money. What is the process which guides this activity? If there is a family member who is willing to pay for the repatriation of a person who is at the detention center, what could stop that activity from happening?
In some cases, the person may not have a valid travel document. In some cases, the person may not have a valid visas to go through the countries that they wish to go. We have had persons in the past who refused to sign their forms to get the visas to go through the countries that they need to. And so even if the ticket is provided, they just cannot travel.
How many persons you have like that at the detention center?
At present?
Yeah.
I don't know of anybody like that at present. You mean who have provided tickets and are not allowed to go?
How many persons you have who are in this category where they don't have the visa and the countries that they have to pass through? How many people you have like that at the detention center at this point in time?
Could you repeat the question, please?
How many persons you have at your detention center who do not possess a visa to be sent back to the country, or they don't have a visa to pass through a particular country to go to where they have to land?
Okay. So most of those cases are the African
How
nationals.
many persons do you have like that?
I cannot tell you offhand how many. Okay, so approximately 25 persons from the African continent who would need to have valid travel documents.
And how long have they been there?
Various periods.
An average?
Approximately 2 years.
2 years. Mm-hmm. And what is the plan to have them repatriated at this point in time?
There are a number of challenges in repatriating the African nationals, apart from the visas. We have been looking at different routes which would not require a visa for them to travel through, and which routes, of course, are open for their repatriation. We have examined, and we did put forward a proposal, as we had on 2 occasions, to charter an aircraft to go to the African continent. We have been advised that there are no funds available for that exercise. So what we have been doing is approaching the PS to see whether or not, depending on the route, and we have identified one now that takes them through Turkey, which will not require a visa, to purchase tickets for those individuals to leave. We tested it with a couple of them, and they have left. 2 persons left this morning. In fact, someone, a good Samaritan, we'll have to call him, agreed to purchase tickets for 2 individuals to leave. So we are slowly trying to see which routes we can take them through now that the one through Turkey is now available. And it's a little bit circuitous, and we try not to have to send them through too many different countries, because that's when they kind of end up getting lost in the system. Some of them have to be escorted, and of course, the escorts will also have to go through those channels as well. And if someone has to be escorted, then the cost of that repatriation exercise will go up. A number of them have criminal records and have committed criminal offenses, and those persons definitely require escorts. So those persons, we try to take a more direct route. But again, now that certain countries require, and we can't sign a visa application form on their behalf, they have to sign it themselves. We have tried with some repatriation, and the persons themselves on the day to be repatriated decided that they were not going and created a scene at the airport, which resulted in the airline saying they will not take them on board the aircraft because they see them as a risk. So we have been trying, and the Ministry of National Security has made some funds available to us to purchase tickets for those persons who are able to now go through those routes.
Just to clarify, there are about 25 African nationals who are housed at the IDC for the past 2 years on average?
No, not all 25. Okay. Within that 25, there may be about 4 of them or 5 of them who have been there for at least 2 years. 5 of them.
5 of them.
Right.
There for at least 2 years.
And for at least 2 years. And there are a number of challenges with some of them. One of them would have given us, one of them we have not been able to identify because he gave us 4 different nationalities. And every time, he doesn't have a travel document. I think only about a month ago, he provided a travel document for us, and we now have to verify the authenticity of that travel document. He gave us 4 different nationalities. So he was one who remained there. Every time when we interview and the person says, I am from Nigeria, we take fingerprints, photographs, information. The foreign mission would interview them, and then they have to make a check through their system to determine whether that individual is in fact a national of that country. If they come back and tell us, no, this person is definitely not a national, and we go back to interview again, well, no, I'm really not from Nigeria, I'm from Ghana. And we have to go through the process again. That person told us he was from Nigeria, then Ghana, then Senegal, and now there's a document that he provided that says he's from Gambia. So we have written to the authorities in Washington, D.C. to verify that travel document. And for those individuals, that is typically the challenge that we've had in trying to repatriate those who are there for the longest, in identifying them. And then there were those who absolutely, one of them, as I referred to earlier, who simply did not want to go on the aircraft when arrangements were made. and has resisted any attempt at repatriation thereafter.
Does the embassy have any role at all in making sure, because it sounds almost as though an individual who wants to remain in a detention center can simply remain in the detention center by playing, you know, saying different things, not telling the truth, causing a scene at the airport. When does it end?
And that requires a higher decision. Within the ambit of the Immigration Act, there's no provision for us to release such a person, to grant that person any kind of immigration status. That person has been ordered deported and has to leave the country. The embassies, their involvement typically would be to provide a travel document for that individual and confirm their nationality. And their responsibility ends at that point. They will go and they will visit, they will try to coerce them to cooperate with the Immigration Division for their repatriation. But ultimately, it is up to the individual to leave, and to leave willingly. Like I said, some of them, we make all of the arrangements, they get to the airport, some of them have gotten on the aircraft and then decided that they will act up, and of course the pilot would have put everybody off the aircraft and said that they're not taking them. So,
thank you very much. And that raises for me, Madam Chair, thank you, Madam Chair, a follow-up with respect to, I'm putting myself in the situation of someone who is in the detention center and who is giving your officers trouble. And if I am that person, most likely I am afraid to return to my country. What I am asking is, what is the procedure for dealing with someone who has claimed that he is fleeing persecution of one form or the other from his country, and he's a refugee in Trinidad, he's seeking refuge in Trinidad and Tobago? Do we follow the relevant protocols, and if so, what are these protocols for refugees?
There is a system in place. Of course, there is no national mechanism. There are no laws in Trinidad and Tobago to deal with asylum seekers and refugees. There was a cabinet-approved policy at 2014. And since then, we have been working closely with the Living Waters community and the United Nations High Commissioner for Refugees on a system of facilitating those persons who are in fear of returning to their home country. We have standard operating procedures that has been developed and has been signed off by the Honorable Minister in terms of how they are to be treated. Any person who expresses a fear of returning to their home country is referred through the standard operating procedure to the Living Waters community and to UNHCR. There have been a number of the persons at the detention center who have gone through that arrangement. They have been interviewed by UNHCR and were deemed not to be refugees. They did not have a claim. So those persons remain at the detention center because they would have gone through all of the processes. So that we have in the Immigration Division, as part of the arrangement to deal with the growing problem of asylum seekers in Trinidad, we have set up a refugee unit so that those persons who go to Living Waters come to immigration, we know who they are, we open a file, and we monitor them throughout the process while they go through the interview process with UNHCR. At this point, UNHCR are the ones who make the final determination as to who is a refugee, and they would send that information to us, and there's a process. Once they're recognized as a refugee, we immediately release them from the detention center. And we are working now on a process with the Ministry of National Security to put those persons perhaps on a minister's permit, which is the only thing really under the Immigration Act right now that we can use to facilitate these individuals. So there are a number of things in place. There is draft legislation that went to LRC. And so there's a process now that we're developing to try to address this issue of asylum seekers and refugees.
Thank you very much. So is it that once you have the necessary legislation governing refugees in Trinidad and Tobago, the process that you face with respect to dealing with detainees can be expedited?
Yes, once they claim that they are seeking asylum, Not all of them say they're an asylum seeker. So once that person has expressed that fear, that well-founded fear of persecution, there's a process in place right now to treat with those individuals. And those individuals, like I said, if they are recognized as a refugee, are not kept at the detention center. In fact, right now, once they have been registered with UNHCR, especially those who would come to our attention now, and there are claims, and UNHCR issues an asylum seeker certificate to this individual, we put them on an order of supervision, and so they do not remain in detention.
My question was, what would legislation do in addition to the process you currently have to expedite the processing of refugees?
Legislation would then put the onus on some national body, whether it be the Immigration Division, to now treat with all of these individuals who are claiming asylum. Because there's a distinction with those who are claiming asylum and who might simply have entered the country illegally. They are not claiming asylum, or they might be in breach of some other immigration, some part of the Immigration Act.
Once, just to follow up there, once they enter the country, once they're detained, if they do not request, do they all request legal representation, or is that provided for them? Because one of the issues raised was that detainees are not advised of their right to seek asylum. So how is that done? If they are detained, they all require legal representation, and that is provided if they can't provide their own?
Typically, if they require legal representation, they can ask for it. We will make arrangements for them to get legal representation. And that comes through legal aid. That's not paid for by the Immigration Division.
So it's not a requirement then for them to be legally represented once they are detained?
They can ask for it.
If they don't ask for it, they don't?
If they don't ask for it, it's not provided. Right? Some of them do not want legal representation. Some of them ask for their repatriation as soon as possible. Some of them would ask for a family member to be contacted instead of a legal representative. And all of that, because from the time they're detained, we ask them, what do they have? Do they have some family member here? Is there somebody we can contact for them? And that is afforded to the individual. When it comes to seeking asylum, again, there's no national process in place. We are now working on systems to put in place for persons who say that they are seeking asylum in Trinidad and Tobago. We are waiting for directives as to how we should treat with individuals, whether or not, because there's no legislation, there's no process in place. And an external agency, an international body, are the ones who are making a determination as to who, in fact, is a refugee in Trinidad and Tobago. So that we are still waiting on guidance as to how persons who make a claim, whether or not we are to advise them, yes, you can make a claim for asylum. I am not at liberty to say whether or not we can do that. It is not part of the process, the standard operating procedures that are in place and that have been agreed upon so far. However, anybody who says that they are seeking asylum, they go through this standard operating procedure that we have approval for.
Ms. Kopeseng?
Under the Immigration Act, once a person enters the country under a minister's permit, and let's assume that person continues to live in the country for 5, 10 years, those years do not contribute or add up to give that person residency. So in that instant, what happens to that person who has entered under a minister's permit, one? And secondly, my other question, is a case of Venezuelans. Is it mandatory that you have to purchase airline tickets for them? Or is it that you can use an alternative mode of transport, knowing that we are only 6 miles away? We can use a boat.
I'll take the last question first. Yes, we have sent some persons by boat. They don't have to purchase an airline ticket. and they go to Cedras or to whichever port a vessel is leaving to be repatriated to their country. So that has taken place. In terms of a minister's permit, entry under a minister's permit does not lead to any residence. In fact, if you look at the legislation, it says the minister can order their deportation at the end of it, and it's legislated that it cannot lead to the grant of permanent residence. No period under a minister's permit. More often than not, the minister's permit is a last resort, and most of the persons who should get a minister's permit are persons who are actually deportable. So the minister can allow a person to remain, even somebody who has been ordered deported, to remain for a period of time no longer than 12 months, and the minister may renew that or give another minister's permit for another period of time. And yes, that could go on indefinitely as long as a minister agrees to give a minister's permit. For refugees, that would not be the ideal thing, and it is in the draft legislation we are making some recommendation, as in other jurisdictions, where some kind of temporary immigration status can be granted to those persons who are in fact recognized as refugees. But we do need legislation for that.
Under the Act, you can only grant a minister's permit for 3 years. So after the 3 years, perhaps that person has to be deported.
Well, we are hoping that things can happen before that. Like I said, this is a kind of stopgap measure because there's no provision in law to treat with refugees. So this is really a kind of stopgap measure to have something legally in their hand for them to remain in the country, right? I would hope that it doesn't take 3 years. And what happens then? In fact, UNHCR also reviews the cases and the countries of origin ever so often because they issue a refugee certificate only for 1 year. And they review every year after that, and they will issue another one, or they may issue for 2 years, depending on the country. And they review the cases all the time before issuing another certificate. So in our submission, we are trying to align ourselves with that system, but we are hoping that some measures could be put in place before 3 years.
Mr. Ford, and then Senator Hussain.
Madam Chair, I just want to go back, permit me just to go back to the figure that Mrs. Joanne Nelson Joel quoted with regards to the 25 individuals from the African continent, which is Appendix 5 that you all would have provided to us. And, you know, it's interesting to know that out of the 25, Madam Chair, 19 of those persons are from Nigeria. So again, a simple question is that no special arrangement can be made if those 19 individuals can be accommodated. And then when you look at the other 6, it's 5 from Ghana, 1 from Gambia, and 1 from Sierra Leone. In order to get a plane into the African continent, into Nigeria for the 19 individuals, and then, I know I'm saying it's simple, but you will have to guide me. What are the ramifications?
On the last 2 occasions, we had a number of persons from Ghana and from Nigeria. With the ECOWAS countries, they can land in one country and then they can make their way to another ECOWAS country. Sometimes we might be able to purchase a ticket from them from that particular, let's say they land in Nigeria, to the other African country that they're going to. To charter an aircraft, we have to tell the charterers where we're going, where we want to go, and they determine how much persons can be put on that aircraft. The last time we checked with an airline, it was costing anywhere from $500 to about $650,000 US to charter an aircraft. And it depends on the arrangement. Sometimes they do not return to Trinidad. So for the escorts, because it's not just the detainee or the deportees, you also have to have a number of escorts going with them on the aircraft. And the airline would determine those arrangements, how many escorts we need to put with each individual. We had 2 charters in the past. The last one would have cost us about $3 million, and we were able then to charter a Caribbean Airlines flight. That's when they had the wide-bodied aircraft going to London. And we were able to use that aircraft at the cost of just around $3 million. There was one prior to that that cost us, I think that was $5 million. That one cost us somewhere in 2013. We had done the first one because there were a large number of African nationals again. So when we did this, and some of the African nationals, 19, now this 25 is down from the 45 that we had previously when we started looking at chartering an aircraft. So we've been able to reduce the number of persons from the African continent from just about 49 to now 25. The Nigerians have always been the largest number, and of this number for the Nigerians, some of them, like I said, have criminal offenses. Most of them have entered the country illegally. So trying to repatriate them now, chartering an aircraft now may not, for the 25 or even the 19, may not make sense with the numbers that we're looking at, the figures that we're looking at. So we have written to the Permanent Secretary asking for funds in order to repatriate them now that this different route is available to us.
And again, I must make mention, keep in mind the food bill.
Yes.
Nice. All right.
Yes.
I just want to go close to home now. My last question.
Before you go there, what is the cost of buying the tickets then?
The purchase of the ticket, a ticket would probably cost around $35,000, depending on the time of the year, $35,000 to $45,000.
So it's much less than the...
Yeah, exactly.
Okay.
If there are escorts to go with them, then of course it's 3 escorts we're talking about, and we have to purchase a return ticket and all of the meals and the hotel accommodations and whatnot for the escorts. So it could run well over $200,000 for any repatriation if there is to be if the person has to be escorted.
Madam Chair, we should note as well that the airlines have specific restrictions as regards the amount of detainees that can travel on any particular flight at one time.
I would imagine so.
Yes.
Enough with a
Yes. Because they say they cannot carry more than 2.
Yes.
2 is their absolute maximum.
Yeah.
1 week you could carry 2.
And like I said, each of them has to have 3 escorts once any leg of the journey is over 8 hours. That's the requirement.
Madam Chair, I want to, you see, being an associate, I think I heard the comment made, we slowly repatriate them. And I feel more effort must be made to deal with this issue. Because the word slowly, and now we are looking at issues, we are looking at the problems to dictate what we have to do. And yes, we look at the problems, but when we look at the problems, like we talk about, we can't put more than 2 persons on an aircraft. That would mean in a month you could carry the 10 persons. If we make a schedule, of how we're going to get these people out of the detention center, it could be solved. And as I'm saying that, I want to refer specifically to what we are looking at, the current number of detainees as at March 2018. We still have 81 Venezuelans in the detention center, as stated in your appendix here. And, you know, it tells a story. Is the story to have another prison set up there, or is it a story to deal with and repatriate people back to where they came from?
Right.
Mr. Ford?
All right, so my colleague just touched on the point that I want to make, which is with regards to the Venezuelans, right? With your present list, Appendix 5, right, we have a total of 81 Venezuelans out of a total of 126 detainees as of March 19, 2018. So we are seeing that the trend has changed from the African continents, from our Caribbean neighbors, as the case may be, 81. When we go through this particular document, in 2015, male detainees, Venezuelans, 29. Female detainees in 2015, 0. We go to 2016 male detainees, we had a total of 125 male Venezuelan detainees. We had a female total of 97, 2016. 2017, male detainees, Venezuelans, 145. Female detainees, 2017, 82. Right, so we are seeing where the numbers are increasing as a result of what's happening to our next door neighbors. My question to Chief Immigration Officer, what proactive systems are being put in place in order to manage this situation, in order to alleviate it, in order to... What plans you all have with regards to the Venezuelan scenario, to simply put it?
The Venezuelan situation right now is, I would say, complex, in that more and more of the individuals are entering the country illegally. Our figures show that the numbers that arrived at a legal port of entry or via air, let's say via air, decreased significantly since the situation in Venezuela developed. More persons are now arriving by sea. At least 150 to 200 Venezuelan nationals arrive by boat every week from Venezuela. But the numbers that we are seeing at the detention center, the majority of them, at least 90% of those persons, have entered the country illegally or have a criminal conviction, either possession of drugs for the purpose of trafficking or possession of arms and ammunition. So it's changing. And most of them are no longer coming with a travel document. Some may come with a cedula, some will come with nothing at all. And we rely on the Venezuelan authorities to interview their persons and issue some kind of identity documents for them. That now, we had a nice system where they were doing it quite frequently. Now it is not so forthcoming. In fact, there are only certain days that the officers can go to the Venezuelan embassy to get any kind of information on the nationals. We continue with our process of advising the Venezuelan authorities when we detain anybody. Our challenge right now is identifying people, the Venezuelan nationals, as Venezuelan nationals. In terms of repatriating them, you first have to get the identity document and confirm that they are Venezuelan national before you can make an arrangement for them to go back to Venezuela. The numbers that we are seeing now, and right now, as a matter of fact, we have 37 males and 30 females, 67 Venezuelan nationals we have in detention at this present point in time.
Different from your documents today?
Yes, and as I said, it's very fluid.
Very fluid.
Some persons would have left,
okay.
right? And then, like I said, by this evening, it may very well change after we interview the 50-something persons who are currently at stations following police exercises. So that figure may even change by tonight.
And this is one of the easiest amount of individuals they can get out of the country?
It's not so easy. Once we have the identity documents, we then have to make arrangements for their repatriation in terms of the purchase of either a ticket or the purchase of a boat ticket for them to leave, right? That is not as easy as it sounds. You would have, when we did that walkthrough at the detention center with the Honorable Minister, there were plans, once with the agreement of the Venezuelans, for our Coast Guard vessel to take persons to Venezuela. That has not yet materialized, and the discussions are still ongoing. There are only so many persons who can go on any of these vessels, right, to Venezuela. Some of them don't want to go by boat to Pedernales or to Copita because they say it's far away from the city in which they actually live, and they prefer to fly. Caribbean Airlines only has, I don't think they have a daily flight to Caracas. So it depends on the availability of the flight.
Just to ask, they have a choice?
They don't have a choice really, but at the end of the day, we try, I mean, we have to try to be, you know, accommodating to the individuals.
Human rights.
We're talking human rights today, right? And we're not giving them any money to buy a bus ticket to go from where we're dropping them off to go to whichever state or city they might be living in. Venezuela is a huge country. And when the state provides me maybe with money to give them a stipend to go back home, all well and good. But some of them have no money. They come with no money, and they're leaving without any money. And therefore, we try as far as possible to get either contact their family members through the Venezuelan embassy. Sometimes persons may try to call the family members to send money for them and whatnot.
So the embassy has no role in even assisting them to get from where we can drop them in their country?
No.
But this is the responsibility of us to drop them in their country, and that is the responsibility of our country.
Well,
what is
I
really
would
the
say,
responsibility of our country?
headline,
Is it to get them to their land?
Yes.
How far does our responsibility go?
And I would agree with that, that we could just take them and drop them anywhere in Venezuela and let them make their way from whatever point we drop them off at. But I think it would either be irresponsible of us as a government and as an organization to try to do something like that and just leave them wherever it is.
I didn't mean to say anyway. I meant a port of entry.
And
Is
it
it a
depends on
responsibility of this government to drop them to a port of entry within their country? Because
Yes.
when they land in their country, then their government, they would pick up another type of responsibility with people landing there.
And
Because
I
when
would
people
say
are dropped off in Trinidad at the Piaco airport, they may live in Matlat.
Yes.
But they are dropped off in Piaco airport, and we have our facilities where we pick up persons dropped off at our airport. So I'm just drawing an example that we can drop off persons at that port, an appropriate port within the country, a recognized port in Venezuela.
And I would agree with that. And what we try to do and what we would have to do is ensure that their family members are notified when they are leaving and, you know, what port they would be arriving at, and then try to make arrangements. Because even those persons who are coming back who are being deported, Trinidad nationals who are being deported from any country, those arrangements are made. We contact family members and whatnot. Even as immigration, if we ask them when they return, where are you going to when you leave here? I don't know. We would not leave them put them outside to the wolves. We would try to contact somebody for those individuals. Right? So it does require some communication with their family members, and I agree, yes, we can drop them off at any port, but facilitate some communication with their embassy and their family members that this is where these individuals are going. And we do advise the mission when the individual is being repatriated.
Final question, Madam Chair. Between 2016 to present, how many Venezuelans would have entered Trinidad and Tobago? I know we're dealing with detainees, but as the immigration officer, I don't know if you have that statistics here.
I don't have that statistic in terms of those who would have arrived at a legal port of entry. I can certainly provide it to the committee. I know that it was significantly less from my memory, and I would just say that in 2014, 2015, we had something like 60,000 plus Venezuelans arriving in Trinidad and Tobago. From 2015, you started to see the decline. And last year, the figure would have been just around 28,000 Venezuelan nationals arriving at a legal port of entry. Of course, I would have no figure for those who would have entered illegally. I can only surmise the numbers that we are seeing now that we are picking up who have entered the country illegally. We can safely say that larger numbers are arriving illegally into Trinidad and Tobago.
And more being detained?
And more are being detained. And quite a number of them, I would say, have applied for asylum. Because the numbers of Venezuelans who have applied for asylum has gone from, in 2016, 5 of them, to today, well over 1,000, perhaps 2,000 Venezuelan nationals. And daily, those numbers are being added to. All right, so when they come in, they go to the Living Waters community and they apply for asylum at the Living Waters community, and they are then referred to the Immigration Division.
Senator Hossain.
Thank you very much, Chair. Just going back to the detention center itself now, I noticed in your submission you would have indicated the way in which the detainees are allowed to communicate with persons outside, that you would loan them their phones and they would make phone calls. And initially on entry into the center, they would be allowed one phone call, I believe, one initial phone call. Now, what are the options available to those detainees who don't have a cell phone and would like to communicate with their detainee at law, friends or families? And the second question is that most of the detainees who are not charged with any criminal offense, why do you all take their cell phones?
The detainees who do not have a cellular phone, they would be allowed telephone privileges by the immigration officers on duty at the Immigration Detention Center. And sometimes they are allowed use of telephones by fellow detainees. A telephone is considered contraband. That's why it's not something that is kept for security reasons, obviously. All these telephones come with video cameras and all that kind of stuff. So the telephones are received as property when they come in. And on specific days, they are given back these cell phones, they charge it, and they make phone calls and whatnot, and then they return it to us.
Is it the immigration officer gives them a call, but who pays for that call?
Well, the state will be paying for that if they do not have any means of contacting family.
Okay.
Yes.
Well, I want to thank the officials who were here and willingly submitted themselves to our questioning. I want to thank also members of the committee who would have raised important issues as regards this inquiry proposal. At this point, I would like to invite Mrs. Singh, the Acting Permanent Secretary, Ministry of National Security, to make her closing comments.
Thank you, Madam Chairman. Madam Chairman and members of the committee, I wish to thank you for the opportunity to be here, and I trust that given our lengthy discourse this morning, the committee, as well as the viewing public, have been provided with some clarity regarding the treatment of detainees at the Immigration Detention Center and the importance of the detention center as it pertains to the security of our country. And I thank you again.
Thank you, and if I may be allowed just to give a little summary of what we would have discussed, findings, and some of the recommendations that would have come up. One, there's a marked variance between the reports and the conditions at the IDC as expressed by the Ministry of National Security, Immigration Division, and other civil organizations. Two, no independent assessments have been done on the conditions at the IDC, though this is acknowledged as best practice. Three, police officers are used as detention officers. They are not prison officers. However, they receive developmental training as well as medical and psychological assessments. 4, detainees who present symptoms of mental illness are referred to a medical doctor, then a psychiatrist if necessary, and they also can be separated from the general detainee population if necessary. 5, detainees released from prison, whether they are ex-convicts in that case, are in general circulation with the detainee population, and though this is recognized though as not being the best practice at this time. 6, a detainee classification policy is currently being developed. 7, the most common breach of the Immigration Act is split almost evenly between those who have overstayed their time and those who were working illegally and those who entered the country illegally. 8, the best practice of the 1-to-8 ratio of detention officers to detainees could not be substantiated by the figures submitted in the response, but those revised figures will be submitted for that substantiation. 9, detention time average has decreased from 6 months on average to 4 weeks due to increased levels of staffing and attention to the process. Number 10, increases in the costs of supplying food to detainees have been explained by increases in the cost of the actual supplier from the supplier, and that has resulted in an increase in expenditure in the food provisions at the institutions. Very important to Mr. Ford, right? Number 11, detainees are advised of their right to have legal representation. Also, all embassies and high commissions are informed. However, legal aid is available when required. 12, complaints are funneled through detention officers, which is not a robust enough system. nor does it have enough independence to be considered fair. 13, there's an issue with detainees who refuse to leave the country willingly. Some procedure must be developed to allow such persons to be deported expeditiously. 14, all refugees, as recommended by UNHCR, are immediately released from the ICD. Once they express that they are seeking asylum as detainees, they go through the standard operating procedure to be recognized as refugees with UNHCR. This needs to be formalized so that an international agency is not the body determining final refugee status in Trinidad and Tobago. Legislation is currently being drafted to deal with this matter of refugee status. 15, persons are repatriated by boat to countries in close enough proximity to Trinidad and Tobago where possible. 16, the number of Venezuelan detainees is increasing as the number of Venezuelan nationals entering this country illegally increases. 17, chartering an aircraft for repatriation of detainees from the African continent, as has been done in the past, is cost prohibitive, and a route has been identified which should result in those detainees being repatriated more efficiently in the future. 18, there may be too much responsibility assumed by the Immigration Division for deported persons when they reach their homeland. It is suggested that they can be dropped off at a recognized port in their country, and then the responsibility can be transferred to their home country or their families for their internal transport. A couple recommendations. The IDC should initiate ASAP an independent visit by a Human Rights Association to assess their compliance with human rights treaties to which we are signatory. Another recommendation, the detainee classification policy should be developed as soon as possible, and if at all possible by the end of this calendar year. 3, all efforts must be made to separate ex-convicts from the regular detainees who have simply violated immigration laws. And 4, the IDC should develop an independent complaint system for detainees. That being said, I want to thank the officials who were here with us today. I want to thank our viewing and listening public, and really to wish you at the end of this discourse, and to thank you for being and answering all our questions. And we do hope that you enjoy the rest of the day. This meeting is now adjourned.